I think you got a puppy.
I saw my drop there. I dropped it.
Alright.
Like, cool from me.
What breed?
Good job.
Did they still make you pay for it?
There was 3 left. Three are crazy. They're just not sure. Lions.
That's such a weird old I got a spare if we need one. I have a spare if we need one. Okay.
Folks in the audience, just want to be clear that everybody behind the bar has to be wearing a mask, okay? The attorneys are exempt only because they need to communicate with the judge. All right? Sir, in the back, you need a mask?
Mm-hmm.
That's very true. And you don't have to look at your watch. I know, it's cool.
Looking at your watch, you have to do math. It's a red disc. You cast down to 60. So you can see how the disc gets smaller. Tells you how you're doing on time.
All right.
Sir, you may be seated. Calling the habeas petition in the matter of Scott Peterson versus the people of the state of California. Appearances, please, starting with counsel for petitioner. Thank you.
Good morning, Your Honor. Cliff Gardner for Petitioner Scott Peterson.
Good morning.
Good morning, Your Honor. Andres Vargas for Petitioner Scott Peterson.
Good morning.
Good morning, Your Honor. Matt Harris on behalf of Petitioner Scott Peterson.
Thank you. And the record will reflect that Mr. Peterson is present in the courtroom for a respondent, the people.
David Harris for the people.
Birgit Flatiger for the people. Victoria Vasquez for the people.
Thank you. All right, before we begin, this is on for our oral argument of the petition and the evidence in the record. But before we begin, this matter is being live streamed on the court website, and just so that the public knows, members of the public are prohibited from California Rule of Court 1.150 for recording this stream without prior order of the court. That does not apply to media that received an order from the court, but it does apply to the public. Very well. The court has received and reviewed the briefs by counsel and the reply briefs. I may have some questions as we proceed today, but counsel, when you argue, you may take off your masks as well. For everyone else in the public, please keep your masks on. There is a mask requirement in San Mateo County, so while you are seated in the courtroom, please keep your masks on. But for counsel, you may take your masks off when you are providing argument to the court. Mr. Gardner.
Good morning again, Your Honor. It's nice to see that we're all here and all healthy this time.
Correct.
It is, yes. Your Honor, as you may recall, before we had the evidentiary hearing, a few weeks before, there were some hearings on pretrial motions that the parties had brought. And one of those pretrial motions involved the appropriate burdens of proof that the court was to apply in this case. And the court issued a ruling in connection with those motions on February 15th. And what the court said was that there were two distinct burdens. One was an initial burden on petitioner, Mr. Peterson, to prove the existence of jury misconduct. And what the court said, and that had to be proven by a preponderance of the evidence, is that petitioner's burden was to prove a juror had concealed relevant facts or given false answers during voir dire. That was the initial burden placed on petitioner. In the situation where petitioner satisfied that burden, the court went on to note that the burden would shift. There would be a presumption of prejudice, and the burden would shift to the state to establish that that misconduct was harmless. That seemed like a good framework to me then, and it still seems like a good framework to me, Your Honor. And so I thought I'd tailor my relatively brief remarks this morning to those two burdens, whether we've established our initial burden of proving misconduct and whether the state has carried its burden, assuming we have proved misconduct, of establishing that the misconduct was harmless. So let me start with the first question, and that is, did we carry our burden by a preponderance of the evidence of proving the existence of jury misconduct? And I have to say that before we get to the merits of that question, Your Honor, there is sort of a nuanced legal disagreement between the parties. The petitioner's position is very much aligned with what the court said in its February 15th ruling, which is that to carry our burden, we have to prove that a juror has concealed relevant facts or given false answers during voir dire. The state takes a slightly different position. The state's position is that that predicate finding of misconduct is not established simply by the proof of false answers or concealment, but that petitioner, in order to establish his burden, has to also prove that those false answers were intentional. And I just want to take a quick moment, I know this is in the briefs, to say that I believe the state's position cannot be squared with either the language of Manriquez from the Supreme Court or the holdings of Manriquez, Cowan, and Boyette. And I'll just take a moment. Manriquez was a relatively recent 2018 decision of the Supreme Court, where the Supreme Court talked about how a, quote, a juror who conceals relevant facts or gives false answers during the voir dire examination undermines jury selection and commits misconduct. And then they went on to say, such misconduct includes the unintentional concealment, that is, the inadvertent non-disclosure of facts. And so I don't know how the court could have been any clearer to say that the inquiry into intent, which is an important inquiry, and we'll talk about it, I think, in connection with whether the state has carried its burden of rebutting the presumption of correctness, that is not a part of petitioner's initial burden.
So question, Mr. Gardner, how do you reconcile that statement with a false answer?
Well, falsity is going to be determined in some objective sense, and we'll talk about it in a moment in connection with some of Ms. Nice's answers. But let's say, for example, a juror gives a false answer and it's unintentional. We know from Boyette, we know from Enriquez, and we know from Cowan that that's still misconduct. That's why each of those cases found unintentional false answers, but they went on to impose a presumption of correctness, a presumption of prejudice, and they resolved the case by analyzing whether, in fact, the state had rebutted the presumption. Now, obviously, if there had been no misconduct to begin with, there's no need to analyze whether the state has rebutted the presumption. Those cases, I'm sorry. Oh, I'm from New York. That's going to be very difficult to do, but I will try.
And particularly when you read,
yes,
Mr.
okay.
Gardner, if you could slow down. Both the court reporter and I would appreciate it. Thank you.
Well, the court will be pleased to know there isn't much more reading in at least my prepared remarks. So I don't believe that the state's position can be squared either with the language of Manriquez or with the fact that Manriquez, Cowan, and Boyette all went on to resolve the case by looking to see if, in fact, the presumption had been rebutted.
All right, if I could interrupt for a moment. Madam Clerk, could I get this pen does not work, and I'm using a red pen. Thank you. You may proceed.
So that brings us to the merits of whether, in fact, petitioner is established by a preponderance of the evidence that misconduct occurred, that false answers were given or facts were concealed. And I want to focus the court's attention today. Obviously, we briefed all the aspects we believe constitute misconduct, and the court's read that briefing. I want to focus today on two questions in the questionnaire, questions 54 and question 74. I'm sure those come as no surprise to the court that I'm focusing on those. Question 54 was the question that asked, have you ever been involved in a lawsuit? And Ms. Nice answered in the questionnaire, no, I haven't. And in fact, we now know that that was false, that she was involved in two lawsuits, a restraining order lawsuit in 2000 and a civil damages lawsuit sometime thereafter. How do we know? We know because Ms. Nice has told us. Exhibit 1 of the exhibits that were introduced, Your Honor, is the paperwork for the restraining order litigation in November of 2000 and December of 2000. It's handwritten, and in her testimony at the evidentiary hearing, Ms. Nice conceded that, in fact, she was the one who filled out that paperwork and filed that action. I believe there's also a declaration from Ms. Nice in evidence. I think it's Exhibit 10, and in paragraph 19 of that declaration, Ms. Nice admits that, in fact, she was the one who brought that action. So I don't think there's any real dispute as to whether, in fact, she was involved in a lawsuit. She was.
Well, but let's go back for a moment.
Sure.
Lawsuit is a term of art. You agree?
Well, it can be a technical term. I do agree.
Technical term. And not everyone has the same definition of a lawsuit. Your definition of a lawsuit and my definition may be very different from someone who, a member of the public who has never been in a court of law. Agreed?
Agreed.
Okay. So, isn't it, jury questionnaires are they have their place. I think we all agree. And it's used to determine whether or not, just based on the answer, someone could be a fair and impartial juror in a case. So there is a process by which the questionnaire is used to eliminate individuals who really, based on their answers, would not could not sit as a fair juror in a particular case. Agreed?
Agreed?
Okay. But the terms that are used are the terms that are crafted by the attorneys and sometimes the courts involved. I don't know in this case if the trial judge was, but those terms are, the words used are generally generated from the attorneys. Agreed?
I'm sorry, they are?
They are generated in the questionnaire by the attorneys.
Yes, they are.
Okay. And would it not be important then for the attorneys during the actual voir dire to clarify? If a lawsuit may have different meaning and it is important to determine if someone was involved in a restraining order proceeding, one, you either ask the specific question in the questionnaire, agreed?
That could be, certainly.
Okay. Or you follow up during the questioning of the particular juror.
Also true, that could happen, that could and should happen as well.
Okay. There was no follow-up in the record in this case by Mr. Garagos about what the term lawsuit meant, correct?
That's true.
Okay. And so, and he didn't ask Ms. Neese whether or not she had ever been involved in a domestic violence proceeding or a restraining order proceeding, correct?
Correct.
Okay. So, again, and I'm going to ask the people to respond to this. Is there any relevance to that for this court's determination on the habeas? If so, tell me how the court should handle that information or the absence of the information in this proceeding.
Sure. And of course, I'm going to say there is relevance. Mr. Dave Harris, I would never put words in his mouth. He's going to tell you that there's no relevance. Here's why I think it's relevant, and it gets back to the initial point I made about when the inquiry into intent matters.
Okay.
If that answer is false, regardless of whether it was in a good faith belief, the good faith or not good faith of that answer, that no, I haven't been involved in a lawsuit, is relevant. It's relevant in terms of assessing whether the state has rebutted the presumption of correctness, but it's not relevant in assessing whether jury misconduct has occurred initially, because it is, in an objective sense, false. The reason we know it's in an objective sense false, that is the answer, no, I haven't been involved in a lawsuit. The reason we know it's false is because, in fact, that restraining order litigation is a lawsuit. How do we know that? The state has conceded it. In its informal reply in the state Supreme Court, at page 27, the state gave it a good definition when they said, yes, in fact, this is technically a lawsuit, because a lawsuit is defined as a dispute that's given to a court for resolution, a process by which a dispute is resolved by a court. That's a lawsuit. That's what this is. Now, Your Honor's question, and I understand the series of questions Your Honor asked me and where you're going with this, and it is relevant whether her answer was reasonable, that I didn't think it was a lawsuit because it didn't involve money. And we'll get to that when we talk about prejudice. But in connection with the question of the predicate question of misconduct, that answer is false. She was involved in a lawsuit. In fact, the state, I think at pages 33 and 53 of its opening brief, concedes that her answer was, quote, erroneous, end quote. There may be some daylight between an answer that is, quote, erroneous, end quote, and an answer that is false, but I'm not seeing it. I'm sure Mr. Dave Harris will explain the chasm of daylight that there is between those two. But the recognition that, in fact, this answer was erroneous, based on an erroneous understanding of the word lawsuit, I think comes very close to conceding that, in fact, juror misconduct has occurred because the answer was false. But even putting aside the restraining order litigation for a moment, Your Honor, there's the civil damages lawsuit. Again, how do we know that she was involved in a civil damages lawsuit? We know because Ms. Nice told us she was. She told us she was at pages 42 and 43 of the evidentiary hearing, again at page 291. She recalled filling out the paperwork, filing it in court, coming back to court, and dismissing that lawsuit. And she talked about the fact that it was for damages for lost wages. So we know that she was involved in at least 2 lawsuits. Now, the state's position, we talked a little bit about their position as to the restraining order. The state admits that this restraining order was, the answer in connection with the restraining order was erroneous. To me, that's a tacit admission that it was false, and that means misconduct has occurred. Mr. Dave Harris will undoubtedly disagree with my construction of that, but that's our position. With the civil lawsuit, they have a slightly different position, Your Honor. Their position, and Mr. Harris accurately notes, that we didn't provide any documentation of that civil lawsuit. This is at their state's reply brief at pages 7 to 8. And that's true. But that's not the burden on petitioner. The burden on petitioner isn't to provide documents. The burden on petitioner is to establish by a preponderance of the evidence the existence of a lawsuit. And we actually have a slide. Petra, if you would be kind enough to put that up. Here's what Ms. Nice testified to in connection with that lawsuit. I don't know if Your Honor can see that.
I can, thank you.
So is this a question by Mr. Pat Harris? You filed a lawsuit against her for, I believe, lost wages and a number of other things. Is that answered by Ms. Nice? I did. Yeah, clearly I misled the court when I said there'd be no more reading. Question by Mr. Pat Harris. Okay, and so the incident you're describing when you came in and told the judge to dismiss, you're referring to the civil lawsuit? Answer, yes. And at page 291 of the evidentiary hearing, there's similar recollection by Ms. Nice, a little more detailed about the fact that she filled out the paperwork and filed it. So there should be little genuine dispute as to whether Ms. Nice was involved in lawsuits. And that, I think, covers question 54. The other question I'd like to cover in terms of the jury misconduct burden, Your Honor, is question 74. That was the question that asked, it was a sort of a compound question. Question 74 asked Ms. Nice, have you or any close friends or any relatives been the victim or witness of a crime? Wait a moment, Your Honor. I am well recovered from COVID, but still have a raspy throat.
That's all right.
So, we're talking about question 74, which asked whether Ms. Nice had been the victim or witness to a crime, or her friends or her family. I'd like to focus on one aspect, one of those permutations. I think all of them are covered in the briefs, but I'd like to focus on one of those permutations here, and that's the question of whether Ms. Nice herself was the victim of a crime and didn't reveal it. And there are two different incidents, as I'm sure the court is aware of where I'm going. The first is the 923 incident with Ms. Kinsey, and the second is the potential domestic violence incident a year later with Mr. Whiteside. In terms of the 923 incident, which I'll start with, the court needs no detailed discussion of the facts. You heard all the testimony. Basically, Ms. Kinsey shows up at Ms. Nice's house screaming for her to come outside so they can fight. Ms. Kinsey then slashes Eddie Whiteside's tires. She kicks the door into Ms. Nice's home. She then leaves. Subsequently, in the subsequent weeks and months, Ms. Nice moves. Ms. Kinsey finds out where she is. She calls her several times on the phone and hangs up. She says she wants to settle it on the streets, and then one day she follows her. She follows Ms. Nice in a van to her place of work. That's basically the facts involving the 923 incident. And so the question is, was Ms. Nice the victim of any crimes in connection with that incident? And I'll start with the door smashing incident. I believe she was a victim of a crime in connection with Ms. Kinsey kicking in the door, and I believe Ms. Nice told us so. I think we have a slide here as well, Petra, if you'd be kind enough to put that up. This is Mr. Pat Harris asking, she, Kinsey, kicked in the front door of your house. Is that correct? Answer, she did. Question, did you consider that to be a crime? Answer, yeah, sure. So it was a crime, and it was a crime against her, and she's admitted it. And yet, in the questionnaire, when asked, have you ever been the victim of a crime, she said no. What about the stalking? The component of the 923 is where she comes screaming to the house, she kicks in the door, she finds out where Ms. Nice has moved, she calls her, hangs up, we're going to settle it on the streets, follows her in a van.
And Ms. Kinsey is Mr. Whiteside's former girlfriend.
That's correct.
And I believe Ms. Nice's testimony was that when Ms. Kinsey came to the house and kicked at the door, she went upstairs and told Mr. Whiteside, I'm not sure if she said your girlfriend's here, but she left it to him. She didn't remain downstairs.
Correct, I think that's right.
Okay.
But the stalking has a sort of a broader component to it. It's not just what happened that night, but it's the tracking her down, calling her and hanging up, calling her and saying, we're going to settle this on the streets, and then following her in a van. And the question is she the victim of the stalking? And I think, again, Ms. Nice has told us that she was. And this is, I think, page 57 of the transcript. Do you consider her stalking you to be a crime? Answer, sure. So we can debate it, but Ms. Nice didn't debate it. She was the victim of stalking. And I think,
Well, if you look at the question, do you consider her stalking you to be a crime? Do, as in the present day, not did. The last question was did. This question is do. I don't know if that's a distinction without a difference to you, but in other words, today, looking back, and do you consider what she did back then to be stalking is different from did you consider it at the time?
it is different. And so, for example, there could be a change in that time period. In 20 years, I suppose, society could have a different view of a particular course of conduct, where it wasn't considered criminal at one point, and now you realize, now I realize that what happened to me was criminal. That's sort of like what happened in Enriquez. But this is not that. Back in 2000, we all knew what stalking was. There was a stalking statute, and this behavior fits squarely within that stalking statute. Moreover, what we do know, Your Honor, is that Ms. Nice also testified at the evidentiary hearing that but for the continued conduct, not just the incident where she kicked in the door, but for the continued conduct, she would never have sought the restraining order. So clearly, at the time, she thought there was some danger inherent in what Ms. Kinsey was doing, or she wouldn't have told us under oath that the only reason she sought that restraining order is because of what happened after the 923 incident. So I think you're right. The tense of the question may raise an ambiguity, but I think Ms. Nice's remaining testimony resolves that ambiguity.
All right.
Okay? So let's talk a little bit about the domestic violence incident. That's November of 2001. This isn't quite so easy on petition, I think, in terms of whether Ms. Nice is admitted or not, because as Your Honor will recall, she quite plainly and explicitly denied it. So we have two versions of this event. We have the version that's informed by the contemporaneous documents that were admitted at the hearing. That's Exhibit 2, Exhibit 8, page 3, and Exhibit 23. And these documents tell this following story. They tell a story that on the evening of November 2nd, 2001, police were called, and they arrived at Ms. Nice's residence.
You want to slow down?
I'm sorry, Madam Court
That's all
Reporter.
right.
This will slow me, Your Honor.
Okay.
So on November 2nd, 2001, police arrived at Ms. Nice's house late in the evening. Mr. Whiteside is arrested and charged with 5 crimes. He's charged with battery on a spouse, corporal injury to a spouse, false imprisonment, endangering the health of a child, cruelty to a child, and simple battery.
Who called the police that night?
Good question. I think in the evidence, Ms. Nice has said that Eddie Whiteside called police.
Okay.
Okay? So police show up, they arrest Mr. Whiteside, charge him with those 5 offenses. We know from the remaining exhibits that, in fact, he pleads guilty to battery, and the other charges are dismissed. And we know he's ordered to serve, I think, 10 days in county and 104 hours of domestic violence counseling. So we have that version told by the documents. Ms. Nice has come into court 21 years after the incident and said that, in fact, those documents are wrong. There was no domestic violence. Here's the version she gives. She says that on the evening they argued. They argued over, I think she said she believed it was over the fact that Eddie was cheating on her. They argued, they came into the house, she was carrying the baby, she gave the baby to her mom, she closed the bedroom door, and then she started hitting Eddie Whiteside, and he never hit her. That's her testimony.
Correct.
Now, the question is, which one is the credible version? I don't believe the court has to resolve that for purposes of misconduct because of questions 54 and some of the things we've already discussed. There are false answers given. But let's go on, let's proceed down this road. Which of those two versions is correct? The version told by the contemporaneous records or the version Ms. Nice gave 21 years later? And I think there's a number of reasons, 4 reasons in particular, to question Ms. Nice's 2022 testimony about what happened and to credit what, in fact, the documents show, the contemporaneous documents. The first is that Ms. Nice at the evidentiary hearing testified that although Mr. Whiteside was stone cold innocent, she never offered to come forward and tell anyone that. Not the DA, not police. She never told anyone that he was innocent until testifying in court.
I believe her testimony was that the police officer who was at the scene asked her about a bloody lip. And that at the scene, she told the police officer, and she didn't even know she had it, but it was because of braces.
That's true.
And that she did not know Mr. Whiteside had even suffered a conviction until recently. As part of this proceeding, she learned it, but she didn't know back then.
My recollection of the record is a little bit different. My recollection is that she saw police take Mr. Whiteside away that night.
Well, seeing someone take, I agree with you, but that's different from he was convicted of domestic violence.
That is different, but she also testified that she knew he was arrested.
Right?
Okay, so let's scale it back. She knew he's taken by police that night. She knows he's arrested. She doesn't come forward and say anything. More importantly, perhaps, is that Eddie Whiteside never asks her, according to Ms. Nice, to come forward. Now, regardless of what Ms. Nice may have known or not known, Mr. Whiteside knew he was charged. And if, in fact, her version is correct, that is, she handed the baby to her mom, the mom's outside, she closes the bedroom door, she starts hitting Eddie. Eddie would have known that he was innocent. And Eddie knew he was charged, and Eddie knew what he was facing, jail time. Eddie would have asked her to come forward. Ms. Nice, Rochelle, tell them what happened. Tell them the truth. And yet, according to Ms. Nice, Mr. Whiteside never asked her to do that.
Well, okay. So the record, as the court remembers it, and I will go back, was that on that evening, when the police arrived, Ms. Nice's testimony was that she actually used an expletive to the police and said, "I'm not cooperating, get out, I'm not letting you in." And she went back up, either went back upstairs, but she didn't open the door for the police. Agreed?
Well, she was certainly resistant and used expletives when police arrived.
Okay.
I don't recall who actually opened the door, but yes.
All right. And so how should the court view that? In what you're saying, you know, that I should believe the records and what happened versus Ms. Nice's version on the stand about
Well,
what
if I understand the court correctly, the court's concerned that Ms. Nice may have not known he was arrested for domestic violence that night, and so that she wouldn't have had motive to come forward.
Correct.
Let's assume that's correct. She didn't
Okay.
know that night that he was arrested for domestic violence. They were living together. At some point, she must have known that he was arrested for domestic violence. But let's put that aside. Eddie Whiteside knew he was arrested for domestic violence. And according to Ms. Nice, he never even asked her to come forward and tell the truth. So regardless of what she knew in terms of when he was arrested, and I think she did know he was arrested that night, Your Honor can say, well, she might not have known the charges, and perhaps that's true. But Eddie Whiteside certainly knew the charges. And if he never asked her, at least I believe her 2022 testimony that in fact he was stone cold innocent is suspect. If someone's innocent and you have a witness, at least once you're charged, you ask them to come forward. It's inconceivable to me that Eddie Whiteside would not at least have asked her, "Michelle, please come forward and tell the truth."
Is Eddie Whiteside's race in this record?
Is Eddie Whiteside what?
His race. Is it in the
Eddie
record?
Whiteside's race in the record? I don't know.
Right.
I don't know, Your Honor.
Okay. So he in 2001 is arrested by the police. Ms. Nice knows that.
Yes.
Okay. The court gave petitioner the opportunity to subpoena Mr. Whiteside. In fact, the court continued the hearing to give additional time for petitioner to secure his testimony at the hearing. Is that correct?
Yes, it is.
And in fact, Mr. Pat Harris told the court that you had subpoenaed Mr. Whiteside, correct?
I don't recall if Mr. Harris told the court that or not. I'm not disputing the court's recollection. I just don't
The
recall.
court's memory is that Mr. Pat Harris said we were able to subpoena Mr. Whiteside. He wasn't happy about it, but that the petitioner chose not to call Mr. Whiteside without knowing what Mr. Whiteside was going to say. So my point is that the petitioner had an opportunity to call Mr. Whiteside at this hearing, but failed to do so because you had him under subpoena.
Sure, I'll accept that for the moment because I
Okay.
can't recall. But let's be clear, Your Honor, the people had an opportunity to subpoena Mr. Whiteside too in the lead up to this. And since they do have a burden of rebutting the presumption of prejudice at some point, they had a motive to call Mr. Whiteside too and simply present his testimony. No, I never hit her. She's right when she testifies to that. So both parties had an opportunity to call Mr. Whiteside. The fact that petitioner elected not to call a witness who wouldn't speak with him is, as Your Honor knows from her own trial experience, not unusual. It may not be the standard, but it's certainly not unusual that you don't put a witness on the stand who hasn't spoken with you. The third point about the dispute between the contemporaneous documents and Ms. Nice's 2022 testimony is to look at the charges that were brought. Remember, Ms. Nice's version of the events is very simple. We argued, I came into the house, I gave the baby to Mom, I closed the door, and I hit him. Mr. Whiteside is charged with endangering the health of a baby, cruelty to a baby. There's no scenario under which, or that I can think of, under which Ms. Nice's 2022 version of events accounts for that charge. Police they don't just make up charges. They base it on the evidence from their investigation. So I don't believe her current version of what happened accounts for the fact that police charged the case the way they did. I just think they're irreconcilable. And the final point about which of these versions to credit deals with Ms. Nice's 2020 declaration, where she addresses the Eddie Whiteside incident. And I think it's paragraph 27 where she describes this incident with Eddie Whiteside. And she said, the reason I didn't report it or answer or review it on my questionnaire is because since she uses this phrase, and I hope I'm getting it right, Your Honor, but it's close. She uses the phrase, I didn't view his conduct as criminal. I didn't view his conduct as criminal. Now, Your Honor's initial reaction, I can tell as well, it wasn't criminal. He just stood there. And that's true. That's an accurate way to describe what Mr. Whiteside did. But it's a pretty unusual way to describe it. I know Your Honor, in her experience as an advocate, probably drafted declarations. I've drafted declarations. My colleagues from the prosecution have drafted declarations. If the witness comes and tells you, you know what, here's what happened. I hit him. He didn't hit me. It's a pretty unusual way to phrase that in your declaration by saying, I didn't view his conduct as criminal. It's an understatement to say that's an understatement. There was nothing Eddie Whiteside did, according to the 2022 version, that's remotely criminal. Why would you express it by saying, I didn't view his conduct as criminal? You would say, he didn't do anything to me. He didn't hit me. I hit him.
They were in an argument before they came into the house, yes?
They were arguing about her belief that he was cheating on her.
Correct. They were in a verbal altercation.
They were arguing, yes.
Okay. Could that be what she was referring to? The verbal altercation?
I don't believe so. I don't believe so when she says, I didn't view his conduct as criminal. That's why I didn't report it. It's hard for me to imagine whatever she expressed to counsel that led counsel to suggest that this is the language you should use, but it isn't. He never hit me, I hit him. That's a very unusual way of expressing that, Your Honor.
Okay.
Unless the Court has other questions on the existence of misconduct, I'd like to turn and I think, of course, we've established by at least a preponderance of the evidence that there are false answers or evidence that was not revealed. And I think that's all we have to do for the initial predicate question of misconduct. The question then is whether the state has carried the burden of rebutting that presumption of prejudice. Now, I started my misconduct discussion with a point that we disagreed on, Mr. Harris and I, and we've been wrestling with this case for many years. So I'd like to start this section of the discussion with some points of agreement that Mr. Harris and I have. We agree that the most important question, it's not dispositive, but the most important question for the Court in resolving whether the state has rebutted the presumption of correctness is whether the false answers were given intentionally or not. It's not dispositive. An unintentional false answer, as the Supreme Court has said many times, can result in relief, and an intentional nondisclosure sometimes can result in a denial of relief. But it is the most important factor the Court has said a number of times. I think Mr. Harris and I, Mr. Dave Harris and I agree that Ms. Nice is the critical witness for resolving that inquiry. And the resolution of that inquiry involves a number of different steps, which I'd like to go through. One, it involves an assessment of her general credibility as a witness. The factors we would apply to any witness, whether it's
Slow down.
whether it's a...
I will keep reminding you.
Thank you, Your Honor, and I'm sorry to make you do that.
That's all right.
And Madam Court Reporter, I apologize to you as well. Again, let me just say I have a standing apology, if I can do that.
Okay. So, and, we have, I've scheduled this for the entire day, not that it will take the entire day, so feel free to take your time to make all the points that you need.
I'd love to say, Your Honor, that was the reason I was rushing but it wasn't, but I will keep that in mind. So I think we talk about the general credibility factors that are relevant to any witness. We talk about what the state has called the Manriquez factors. Those are factors identified in Re Manriquez, synthesized from a number of cases. And we talk about what Boyette, the Supreme Court decision in Boyette, called the surrounding circumstances. And we try to use all those to assess whether these answers are credible, whether these explanations are credible, whether it was intentional or not. So let me start with the general credibility discussion. Evidence Code 780, which is cited in the brief, lists the factors that fact finders should consider. It's been distilled into a number of different jury instructions, civil and criminal, and I'm sure the court is familiar with it, but just let me, in an excess of caution, I have a slide that conveys a couple of the more important factors for assessing credibility. And this is from Calcrim 226, Your Honor. Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? I'll skip to the bottom one. What is the witness's character for being untruthful? And then the middle one admonishes that we should evaluate the testimony in light of the entire record. So really what we're looking for, at least initially, is a search for consistency. The state points this out in its brief. She's suggesting she's been a consistent witness, and that's a reason to find her credible. So let's explore that for a moment. In 2000, Ms. Nice filled out that paperwork in connection with the restraining order. And here's what she said about whether she was in fear for her baby's life. This is what she said under oath in the paperwork in 2000. Michelle does not want Marcella to be able to come anywhere near her her child after it is born. Michelle feels Marcella will try to hurt the baby with all the hate and anger she has for Michelle. That was under oath in 2000. Here's what Ms. Nice said under oath in 2022 about whether she had fear for her baby. This is Mr. Pat Harris. Okay, did you have a genuine fear that she was going to hurt your child? Nope. You never were afraid of that. Nope. There is, I referred to a chasm before, there's a chasm between those two, both under oath, those two positions, Your Honor. One is there's a tremendous fear with all the anger and fear anger and hate she has for Michelle, and the other is I wasn't in fear at all, never.
Okay, remind me, at the hearing, was this were the questions at the time after the child was born? Because Ms. Kinsey came, the incident arose when Ms. Nice was expecting the child.
Yes.
Okay, so the questions that you're citing to in the transcript, was that about after the child was born or when she was expecting the child?
It's actually, these questions are asking her to explain why she gave a different response in 2000. So they're specifically directed at this portion of the narrative.
Thank you.
It's pages 51 to 56 is where this entire discussion occurs. Here's what Ms. Nice said in 2020 about why Ms. Kinsey showed up at her house there's some dispute as to whether it was in the morning or the evening. Both are in the record, but why she showed up in the house. Here's what Ms. Nice said in her 2020 declaration. My boyfriend, Eddie Whiteside, was the ex-boyfriend of Marcella Kinsey. She was not happy with the current arrangement and came to my apartment to confront me about it. That's paragraph 20 of the evidence of her declaration, which is Evidentiary Hearing Exhibit 10. Here's what she said at the evidentiary hearing about why Ms. Kinsey came to the house that night or that morning. Paragraph 20, Mr. Pat Harris is asking her about this discussion this piece we just talked about. Paragraph 20, please, is that a truthful and accurate statement? Answer, more or less, yes. Question, more or less? Which part of it is less? Answer, she, Kinsey, didn't come to confront me. Again, there's a chasm between these two. Kinsey came to confront her, or she didn't. They're both under oath. There's a stark inconsistency here, and in connection with what we look at, consistency, this is directly relevant to her credibility.
Okay, but we're looking at a statement. How many years between the two statements? The statement was made in, is it 2001?
No, actually, the statement in the 2020 declaration was made in 2020. That's why I called it the 2020 declaration. And the testimony was 2 years later at the evidentiary hearing.
Okay.
So there's a 2-year gap. Here's what Ms. Nice said in that 2020 declaration as to whether she was the victim of a crime. I did not interpret the circumstances leading to the petition for a restraining order as a crime. I still do not. This is again 2020. This is paragraph 20, Exhibit 10 in paragraph 23. Here's what she said in her 2022 testimony. Question by Mr. Pat Harris. She kicked in the front door of your house. Is that correct? She did. Did you consider that to be a crime? Yeah, sure. Again, there's a stark inconsistency there. It's a crime or it's not.
And remind me again, the 2020 declaration was prepared by Mr. Zaki.
Yes.
And Ms. Nice's testimony was that because of COVID, she, you have to find it in the record. She either reviewed it over Zoom or reviewed it over the phone one time.
She didn't review it in person because of COVID.
Because of COVID.
She reviewed it electronically at some distance, whether it was by Zoom or over the phone with him.
All right, thank you.
And I'm sorry, I've already forgotten what I said.
I think you said by phone. By
Oh,
Zoom
by
or
phone,
by
okay, thank you. It's the true bathtub memory. And this last, what I'll call inconsistency, Your Honor, is a little more nuanced, but let me give a crack at explaining it. Because we now know that Ms. Nice testified twice about what happened to her on September of 2000, the basis for the restraining order. She's testified to it twice. She testified to it in December of 2000 in connection with the restraining order litigation, and she testified to it at 2022. And I would love to be able to put up a fancy PowerPoint slide, Your Honor, showing the December 2000 testimony and comparing it to the 2022 testimony, but I cannot because of the age of the restraining order litigation. We were unable to locate a transcript. But here's what we do know. So I don't know what she testified to in front of Judge Pfeiffer on December 13th, 2000 that compelled Judge Pfeiffer to grant that restraining order. But here's what I do know. I do know that under the law at the time, Judge Pfeiffer could not grant that restraining order unless she found, according to Civil Code section or Civil Procedure Code section 527, she had to find clear and convincing evidence of unlawful harassment. And I think I have that section up here. If the judge finds by clear and convincing evidence that unlawful harassment exists, an order shall issue prohibiting the harassment. And recall, this was a petition to prohibit harassment. So that's the standard that Judge Pfeiffer had to find in order to issue a restraining order. Unlawful harassment, what does that mean? I'm relatively new to this area of law. I deal mostly with homicides, Your Honor, so I had to look it up, and what I found was that in that section, harassment is unlawful violence, a credible threat of violence, or a knowing and unlawful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person. So this is what Judge Pfeiffer had to find when Ms. Nice took an oath, testified in December of 2000. She had to find by clear and convincing evidence that there was unlawful harassment. We don't know what she said, but we know that this is what was required by Judge Pfeiffer to find. And we know that Judge Pfeiffer did find it. She issued a restraining order, a 3-year restraining order, in favor of not only Ms. Nice, but in connection with the baby as well. And the last point we know is that in her 2022 testimony, Ms. Nice was trying to explain why it is that she had she was saying she had no fear for her baby, or what kind of fear did she have. And here's what she said in 2022. Question by Mr. Harris, why are you telling us today that you were not in fear of your baby's life? Answer, I said I was in fear if we fought. She wasn't going to deliberately hurt my child. But if we fought and rolled around like some dummies on the ground, then yes, I would be fearful of that. I would lose my child doing something stupid like that. Now, I don't believe, and the court may disagree with me on this, but I don't believe that if Ms. Nice had told Judge Pfeiffer that, if she had told Judge Pfeiffer, I don't believe she would deliberately hurt my child, but I'm afraid that we'll get into a fight and we'll roll around on the ground like dummies, that Judge Pfeiffer would have found clear and convincing evidence of unlawful harassment by Ms. Kinsey.
Well, we're going back on theoreticals because the restraining order requested 2 things. One, a restraining order protecting Ms. Nice, and also her unborn child. So there were 2 parties, that petitioners, if you will, that were asking for protection. And so the court could have issued a restraining order protecting Ms. Nice, I guess not the unborn child. She could have issued a shorter restraining order sometimes is the case, just to let, circumstances cool off. And where in the record is Ms. Kinsey's response? Do we have it?
We don't. We don't have a transcript of that here, but I think Your Honor made a really important point there, is that Judge Pfeiffer could have issued a shorter restraining order. Remember, the claim, Ms. Nice's claim was that we would roll around on the ground, and because I'm pregnant, I'm carrying the baby would be injured. You don't need a 3-year restraining order if that's the testimony in front of you, that you're worried that because you roll around while pregnant, the baby will get injured. You don't need a 3-year restraining order that covers both Ms. Nice and the baby. She extended that restraining order to 2.5 years after the baby was born. And that tells me that the predicate for that, the factual predicate for that, wasn't, Your Honor, I'm afraid we'll roll around on the ground like dummies and she'll hurt the baby in utero. Because that restraining order is 2.5 years after the baby is no longer in utero.
And was Ms. Kinsey, again, in the record, had she been charged criminally at that time, at that point? Do we know?
I don't know the
Because
exact
she was charged criminally for the actions against Mr. Whiteside.
She was charged criminally, I believe, with vandalism, Your Honor, in connection with the 923 incident. But I'm not sure when. So I can't answer that specific question.
Okay. And so we don't know exactly what Judge Pfeiffer had in front of her at the time. In other words, was there other evidence of a restraining order, a criminal restraining order?
We don't.
Protecting the party. So and again, this is just, I mean, you've raised it, but I want to be clear in terms of what's in this record. We don't have what was in front of Judge Pfeiffer, either in terms of evidence or if Judge Pfeiffer ran a klutz check before the hearing, because the statute, and again, we'll need to go back, and I'm going to have the parties do this in post-trial briefing. The statutes for restraining orders, sometimes, and I'm not sure about the civil, but in family law cases, require that the court go through and do a klutz check. Is there another restraining order in the system involving the party? So we don't know if that was done in this case, if there was a restraining order that was part of what Judge Pfeiffer considered at the time, correct?
We don't.
There's an absence of information.
Correct, because of the timing. But let me just say this, that if in fact there is another order between these parties, then Ms. Nice was involved in yet another lawsuit. So I'm not sure this.
No, I'm talking about from the criminal proceeding involving Ms. Kinsey, because she was charged with vandalism for her conduct towards Mr. Whiteside, yes?
She was charged with vandalism. I don't know if it was in connection with the tires or the door.
Okay, thank you.
And I misunderstood the court's question. Yes, if there's a restraining order in connection with a criminal case, then that would obviously not suggest that Ms. Nice was involved in another lawsuit. I thought you meant another civil one. So those are, in fact, I think, some important inconsistencies in Ms. Nice's versions of events, evolution of her versions of events from 2000 to 2020 to 2022, that suggests that she hasn't been as consistent as we would like in a witness that we're going to find credible. Which brings us to the Manriquez factors. These are the factors that the Supreme Court in re Manriquez synthesizes from a number of jury misconduct cases. They're not factors that the court announced for the first time in Manriquez. It's a synthesis of a long-time California law. And one of there's a number of factors, but one of them is, did the juror, in assessing whether the juror's testimony is credible and whether she gave false answers, he or she gave false answers intentionally or not, one of the things we look at is whether they cooperated with the search for truth in the post-trial context. Manriquez, of course, is a good example. So is, I think, San Nicolas. Manriquez was a case where the juror did not reveal that she had been abused as a child 40 or 50 years earlier. During jury selection, she didn't reveal it. But in a post-trial questionnaire filled out within days of trial, she revealed it. And then she spoke with both lawyers about it, both lawyers representing the defendant and the prosecution. She signed 2 declarations, and then she willingly testified. And the court, a number of times in the opinion, cooperated that a juror who is sincere when she says she genuinely forgot it and explained it, this is how that juror would react. This juror cooperated with both sides in the search for truth. Same thing with the juror, I think, in San Nicolas, who 2 months after trial, talking to defense counsel, brought up the fact that he had not revealed. And the court said if he was intentionally not revealing it, why would he affirmatively bring it up in a conversation with defense counsel? That's the type of cooperation that the Manriquez factor focuses on. So what do we have here? Well, we don't have that. We have a jury that admittedly spoke with a defense investigator before the habeas petition was filed.
2015.
2015.
So how many years after the trial?
10 years after the trial, Your Honor.
Okay.
So she
And
spoke with...
and she voluntarily spoke with
She
the
did.
investigator.
She did speak with the defense investigator. Defense investigator brought up this subject because she just had the documents, asked about it. Ms. Nice responded. When the petition was filed shortly thereafter, within months, things changed. Ms. Nice refused to speak with anyone from the defense. She refused to speak with anyone from the prosecution. She was subpoenaed to testify, as Your Honor knows. She exercised her privilege against self-incrimination, and she refused to testify unless she was given immunity from prosecution. This is as far from a cooperating witness, I think, as you can get. This is as far from, I can see from Your Honor's reaction that there's some tension here.
Well, and I specifically want to ask you about the final instruction. And again, I'm going to ask the parties to find this in the record. 3590. It's the final instruction that any trial court judge gives in a criminal case. And I'm going to read you the second paragraph. Now that the case is over, you, meaning the juror, may choose whether or not to discuss the case in your deliberations with anyone. It doesn't say you must. It doesn't say you shall. It says you may. So how do you reconcile 3590, which is the final instruction of a trial judge, and I'm assuming was the final instruction in this case? How do you reconcile that with your argument now that, well, she didn't cooperate? I mean, she originally did in 2015, and then she decided she was going to get an attorney, and she did ask for immunity. She asserted her Fifth Amendment right. So I'm worried about staying in my lane. So we have an instruction, right? 3590. We have a time lapse between the cases that you cited to the court. It was relatively short after. In Manriquez, it was actually a post-trial questionnaire.
Yes.
The other case, it was within a couple of months. So we're talking about over a decade, one. Number two, we're talking about her invoking her Fifth Amendment right. And I don't know what case says that any court should consider that invocation in making a determination regarding the credibility, even Manriquez, but I'll have you answer that.
Sure, thank you.
Okay.
Thank you for the opportunity. I think Manriquez does stand for that proposition when it broadly says we're looking at whether the witness cooperated. But let me get directly to your question about the jury instruction. And this in some ways echoes my colleague Mr. Dave Harris's position here, which is she had every right to hire a lawyer as she did and exercise the Fifth, and that's true. And that instruction that you've cited, yes, that's a standard instruction given in every case. And I think the point of the California Supreme Court's decision in Manriquez and the decision to look at cooperation is that that instruction was given in Manriquez too, Your Honor. It's a standard instruction. It was given in Cowan. It was given in Boyette. It was given in San Nicolas where they looked at the cooperation. The state is quite right when they say she had every right not to speak with the defense. She had every right to exercise her Fifth Amendment privilege. That's true, but so did the juror in Manriquez, so did the juror in San Nicolas, and they didn't. And that's why it's relevant, Your Honor. And that's why Manriquez says we look at cooperation. It's not that she didn't have the right to do this. She had every right to do it. But when you take that step, there's an inference that can be drawn, and Manriquez says we're permitted to draw that inference. So that's why I think I understand the instruction Your Honor is focusing on, but I think, in fact, it points in our favor because that instruction was given in those other cases as well. It's a standard instruction. The second Manriquez factor, Your Honor, is what I'll call the notice factor. Was the juror who intentionally or unintentionally gave a false answer, was he or she on notice of the relevance of the information? And let me just briefly reference a couple of cases that were relevant on this point. Diaz, a case from the 80s, and Manriquez. Manriquez, the juror said what the juror didn't reveal was her abuse 40 years earlier as a child. And the reason it was important to Mr. Manriquez's case is that the penalty phase of his capital trial, he introduced abuse as a child. And what the court was careful to note was that there was nothing in the publicity in the case or the voir dire that would have alerted the juror CB and Manriquez, that in fact this was important. So that was a factor that suggested it wasn't intentional because she didn't know it was important when she didn't reveal it. Diaz stands in sharp contrast. Diaz was a case where what the juror didn't reveal is that several years earlier she had been, I think, raped at knife point or assaulted with intent to rape at knife point. And the court was clear to say, look, the voir dire made clear that this was a knife attack. And so that should have put you on notice and made you more inclined to think of this information and reveal it. So what do we have here? We have, as the state has properly conceded, I think, recognized that the state Supreme Court said the publicity in this case was not just nationwide, was worldwide. And the parties at trial talked about the fact that there was more publicity here than the O.J. Simpson case. And while the details of the state's case may not have been in all that publicity, the general contours were. And the general contour was that Scott Peterson had assaulted his pregnant wife and killed both her and their unborn baby. That's what jurors were aware of when they came into voir dire. Ms. Nice admitted that she'd seen the general publicity. And so in terms of the notice requirement, Manriquez, should a juror have been on notice that if in fact you feared for your baby's life because you thought you were being assaulted, I think the publicity put Juror Nice on notice that that was an important factor. And I think that Manriquez factor weighs against the state's ability to rebut the presumption of prejudice.
Okay, so let me go back to the jury questionnaire, 97A.
I'm sorry, Your Honor, I don't have 97A.
That's all right, I'll read it to you.
Oh, thanks.
The jurors that sit on this case will be instructed that they must base their decision entirely on the evidence produced in court, comma, not from any outside or pre-existing opinion or attitudes. Can you do that despite what you have read, heard, or seen about this case? She checked no.
She did.
Any follow-up on that from Mr. Garagos?
I don't recall. I assume the parties thought it was a mistake, but I don't know. It seems astonishing to me, Your Honor. It seems absolutely consistent with the idea that she had some kind of predetermined bias in the case, and she was talking about it there, but I don't believe there's any follow-up on it.
Well, but isn't that pretty important to follow up? I mean, the whole reason for these questionnaires is for the attorneys to look at answers carefully and follow up and say, you know, I noticed you've given all these answers right now, but I noticed on 97A you checked no. Ms. Nice, or juror number 7 at the time.
Yes.
Was that a mistake? Can you explain? Isn't that what attorneys are supposed to do?
I agree completely, Your Honor.
Okay. All right.
I was not there, Your Honor, but I agree completely with your assessment.
Okay.
Okay. So the third Manriquez factor is to look directly at the answers, the explanation for the false answers. And we have a number of different answers that at least I suggest we've carried our burden of proving false, and we have a number of different explanations. And so I'd like to briefly go through those. Question 54 was the lawsuit question. And there were 2 different lawsuits. And with respect to the restraining order, there was an explanation given. So Ms. Nice was asked, why didn't you reveal the restraining order on the juror questionnaire when you were asked if you were involved in any lawsuits? And she gave an answer, and she said, as Your Honor suggested earlier, we're back to that, she gave an answer that said, well, I didn't know that I thought a lawsuit had to involve money damages, and this didn't involve money, so I didn't think it was a lawsuit. And the state suggests that the state points out that Ms. Nice is not a lawyer, and therefore that's not an unreasonable determination. And once again, I agree with my colleague, Mr. Dave Harris. That is not an unreasonable explanation. And were it the only explanation in this case, we wouldn't be here. We would have been out of court a lot earlier, Your Honor. And that's why Cal Crim 226 and Evidence Code 780 are so important. We look at all the answers together. We don't just pick out one. Because I think the very next explanation is in substantial tension with that explanation. And the very next explanation deals with the civil damages lawsuit. Ms. Nice was asked, why didn't you put that on the questionnaire? And her answer was, well, there were no subsequent proceedings. I dismissed it. Okay, so if you didn't reveal the restraining order because you thought it didn't involve damages, the civil lawsuit did involve damages, so you should have revealed that. And if you didn't reveal the civil lawsuit because you dismissed it and there were no subsequent proceedings, You should have revealed the restraining order litigation, because not only were there subsequent proceedings, you testified in December of 2000, but there were the subsequent violations that were directly related to it. So there's a tension. They're not irreconcilable, I know that, but there's a tension between them that if it doesn't raise a red flag, it raises a yellow flag. And that's why the CalPRIM and Evidence Code 780 are important. We have to look at everything together. So let's look at some of the other explanations that were given. Can't just...
Doesn't CalPRIM 226, I don't have it in front of me, but it talks about how people sometimes forget things, honestly forget things, or make mistakes about what they remember. And that's, that I agree with you. 226 is an important instruction, and every trial judge up and down the state reads that instruction when they tell the jurors this is how you're to look at the evidence. But people can honestly, forget things or make mistakes about what they remember, and it's up to the jurors to choose based on all the evidence whether or not they believe that the person honestly doesn't remember or that they were not being truthful. That's what the instruction says.
Yes, that's true, and that's the important point about looking at it all together.
Okay.
And so let's talk about some of the other explanations. Okay. I think there's a tension here. It's not, I concede it's not irreconcilable. She could have forgotten one and misremembered another, certainly. So let's look at some of the other explanations. Let's talk about her explanation as to why she didn't reveal what I'll call the door smashing and stalking incident from 923, the Kinsey incident. She offered actually a number of explanations for this, which to me in itself is a little curious. It was a landlord's door. My mom was living there. Minor indignities. I have a slightly different definition of victimhood than many people, and I never testified at a criminal trial. The fact that there's a number of explanations offered and offered by the state to defend this, I think itself is concerning. But let's take them one at a time, Your Honor. I think at pages 16 to 17 of their reply brief, the state argues as follows. Petra, I think we have a slide. The door damage was to the landlord's door where her mother was residing. So let me break that down. The landlord's door where the money was residing, that's where her mother was residing. That's why it wasn't revealed. And that's why it's important to look at all these answers together. The state, I think, correctly notes that Ms. Nice is not a lawyer, and that's why her response to the lawsuit question, she says she didn't know that a lawsuit, she thought a lawsuit required damages, and so the restraining order didn't, and that's a perfectly reasonable explanation for a non-lawyer. Here the state's position is a bit different. Apparently, Ms. Nice, when she answers the questionnaire, is making a distinction between the landlord's ownership interest in the property and her interest, possessory interest, as a tenant for 9 years. Now, I don't believe that's reasonable for anyone to make. Perhaps a first-year law student excited about property law would. But I don't believe that's reasonable that anyone would make, much less a juror who the state has pointed out a number of times is not a lawyer. And so we can accept her explanation about the lawsuit. It's not reasonable that she would make this fine distinction between ownership interest and possessory interest.
So this is the respondent state's crafting of their argument in the brief. This is not Ms. Nice's testimony. Am I correct?
This is the crafting. I'm sorry, Your Honor.
No, go ahead.
This is indeed the way the state has crafted its defense. But to the state's credit, they did ask, was it the landlord's door? And she said yes. And they did ask, Ms. Nice testified the fact that she wasn't on the lease, her mother was on the lease. And that's really the next point I wanted to point out in terms of the testimony, is the suggestion that this was where her mom was residing. That's true, but it's not entirely true. Ms. Nice herself testified, I think, Petra, thank you. How long did you live at this house? Answer, for years. I don't know how many. Question, approximately 9 years. Does that sound right? Answer, sure. So Ms. Nice was living there with her mother for 9 years. The suggestion that she would have thought when answering this questionnaire that it was a landlord's door, I don't have to worry about this, is, I think, unreasonable, especially someone who the state points out is not a lawyer.
Okay. So would we agree when you look at the questionnaire as a whole, and now that Ms. Nice has testified, that she is a person with a limited educational background? Agreed?
I suppose so, Your Honor.
Okay. And Mr. Pat Harris raised questions during her testimony about the fact that she didn't know where her mother or her father were born. Do you remember that?
I do remember that.
How is that relevant in this case? if at all?
I'm puzzled to see the connection. I'm desperately trying to find one because I know Your Honor must think it's relevant. But I don't see the relevance, at least off the cuff, Your Honor.
Okay.
The fact that she didn't know, or she said she didn't know where her parents were born. I suspect, from my assessment of Ms. Nice's testimony, she was a feisty witness, and good for her. I suspect that the question marks as to where your parents were born were more in the sense of, it's none of your business, than I genuinely don't know where my parents were born.
Well, there wasn't follow-up on that either, right?
Correct. And I think there was no follow-up on that as opposed to, I think, 97 that you asked me about, because
Right.
it probably wasn't central to the case as to where your parents were born.
Okay, but it was, but I guess my point is, but it was brought up in this evidentiary hearing. I believe I sustained an objection after a couple of follow-up questions. But, just looking at the questionnaire generally, again, going back to her responses, and you start with the questionnaire, they have to have a purpose, and the purpose is to kind of give some indication to the attorneys about the educational background, the life experiences of the juror, and the court notes that there were several inconsistencies in this questionnaire, right?
Yes, Your Honor.
Okay. And, for example, she talks about, there was a question about educational background, and had she ever had training, just a moment. So questions 27 and 28. What's your highest level of education? Some college or tech school. Please list all degrees. She says medical assistant, CNA. The next question. Have you ever studied or received training in medicine, psychology, psychiatry, social work, sociology, or counseling? She says no. That's the very next question, or in the question before, she said she had training as a medical assistant in CNA. So I guess, looking at the questionnaire as a whole, there were inconsistencies known to Mr. Garagos and Mr. Pat Harris at the time they were conducting their questioning of Juror 7. Agreed?
Yes.
Okay. So getting back to your door smashing incident, your position is that this explanation about the landlord's door is too nuanced for the court to really find credible.
I believe it's too nuanced for the court to find credible for someone who's not a lawyer, for a layperson. Most people who have lived in a place for 9 years, if someone's screaming outside their house, I mean, let's be candid. Ms. Kinsey didn't come and scream for the landlord to come out of the house. She didn't kick in the door to meet the landlord. She didn't track the landlord down and call and hang up, and she didn't suggest to the landlord that we need to settle this on the street. This was between Marcella Kinsey and Ms. Nice. The landlord really didn't feature into any of Ms. Kinsey's actions, Your Honor.
Okay.
So let me move to the second one of these, the broader explanations, the minor indignity explanation that Ms. Nice put in her declaration and testified a little bit about at the hearing. These were just, she has a slightly different understanding or impression of what it means to be a victim, and this didn't rise to that standard. Let me talk a little bit. We've talked about the facts of the 923 incident, but when someone comes to your house screaming for you to come out so they can fight you, slashes your boyfriend's tires, kicks in your door, follows you to your new place, calls you, hangs up, says we're going to settle it on the streets, and then follows you in a car one day to work, by anybody's standard, I don't think that's a minor indignity. I don't think it's reasonable to say that's a minor indignity. And perhaps more importantly, since I suspect this is the question on Your Honor's lips, I don't believe it meets the minor indignity standard that Ms. Nice herself gave the court. Here's what Ms. Nice described as a minor indignity. Minor indignities, shoving matches, raising of voices, and other undignified means of communicating frustration do not stick out to me, let alone cause me to feel victimized the way the law might define that term. And let me just say, this is perhaps the even more rare moment where I agree with Ms. Nice. This is a pretty good definition of a minor indignity. Shoving matches?
Shoving matches could be it can be a battery, a criminal battery.
Well, I view shoving matches as something, I'm not going to do this to Ms. Vasquez.
I know, but an unpermitted touching constitutes, I don't have the instruction in front of me, but
Yes.
under the penal code, you know probably better than I do, constitutes unpermitted touching of another individual is a criminal battery.
It is a
Okay.
criminal battery. But putting aside what level we can say shoving matches really conveys, whether it conveys a serious shoving match or simply a bump, raising of voices, other undignified means of communicating frustration, that would certainly, I think we would agree, that is a minor indignity. But that is not what happened on the evening of 9/23. This wasn't a raising of voices and undignified means of communicating frustration. This was slashing tires, kicking in a door, getting her new address, calling her, hanging up, telling her she's going to settle it on the streets, and then following her in a van, suggesting she was stalked. I don't believe, even under Ms. Nice's definition, that would qualify as a minor indignity, but it certainly doesn't qualify as a minor indignity under any objective sense of the term.
So when did and again, Mr. David Harris, you can address this when the people address the court, but the timeline. According to Ms. Nice, she and Ms. Kinsey sort of made up. Bygones be bygones. Yes?
I understand the testimony.
No, she didn't use the term bygones be bygones.
No.
But the evidence, the record evidence is that at some point, Ms. Nice and Ms. Kinsey made up about this dispute over Mr. Whiteside. Agreed?
Let me qualify my agreement, Your Honor. Yes, there is testimony where Ms. Nice says, at some point we were standing outside court and we said, all this over Eddie Whiteside. I'm paraphrasing also,
Okay,
and
yes.
I'm paraphrasing too quickly. All this about Eddie Whiteside, let's essentially let bygones be bygones. There is that testimony, but there's also testimony that after that, she called in a restraining order violation. So, and I think she said, well, I wasn't so sure that we were in agreement on this. That's my recollection of the timing.
Yeah, it would be helpful, Mr. David Harris and counsel, since we're going to have just a supplemental post-trial briefing. And one of the reasons I'm doing that, just so both parties know, is to give you an opportunity to have a last word, if you will, to the court about these questions, because I realize that I'm asking questions that may be new and were not included in your briefing. So I feel the case is important and you should have that opportunity. But yeah, so the court's memory was the same as yours, that it was like, why are we doing this, Mr. Whiteside, this is ridiculous. But the court's memory is also that she was maybe in the hospital and had delivered a second baby with Mr. Whiteside, and she saw on a video that Ms. Kinsey was at a party holding the first child that she had with Mr. Whiteside, and that's what got her upset. That is the court's memory. Again, we're going to have to go back and look. That's why she got upset.
My memory is consistent with Your Honor, is that after the bygones be bygones semi-makeup, that there was a period she was in the hospital, she saw what she saw on video, and she called in the restraining order violation.
Okay.
The final explanation for why she didn't view herself as a victim is her testimony that, or her position, I think it's taken in her declaration, that she never testified at a criminal proceeding, and therefore she's not a victim. You know, it's difficult for me to articulate how strongly I feel about this one. If Your Honor's car gets stolen and no one is ever prosecuted, is Your Honor a victim of a car theft? Of course she is. If I walk out of court today and I'm robbed of $500 in cash and no one is ever caught and prosecuted, am I the victim of robbery? Of course I'm the victim of robbery. The idea that you're not a victim if there's no criminal proceeding is, to me, fundamentally unreasonable and not something that Your Honor can credit as a legitimate explanation. It's just so far beyond the bounds of rationality, I think.
But the court's left the facts of this case. And the facts of this case are, you have an ex-girlfriend, you have the current significant other, I'm not sure the appropriate phrase to use, but Ms. Nice was living with Mr. Whiteside. His ex-girlfriend comes to the house. I mean, I think you appropriately said that Ms. Nice on the stand was feisty, and I think we all agree. She has, her life experience is very different from your experience and perhaps my experience. Agreed?
Agreed, Your Honor.
Okay. And so, in the context, I agree with you. I know if my car is stolen, I'm a victim of a crime. I know if someone, takes my purse or my cell phone, I'm a victim of a crime. But the lens through which you and I look at things is different from the facts of this case, because these people knew one another, there was a history, they made up, Ms. Kinsey, and so I think it's more complicated. I understand what you're saying, but I think it's a little more complicated given the facts of this case, because it wasn't a stranger who came to kick the door. It was someone that was known to both of the parties. So I understand what you're saying, but I think it's a little more nuanced, I guess.
I agree with the fact that it's more nuanced, but I'm not sure it cuts the way Your Honor's question suggests. If I, for example, if I know my best friend steals my car and drives it off and he's never prosecuted, I still know I'm the victim of car theft. The fact that it's a friend may make it worse, not better, it seems to me.
Okay.
I just think, regardless of the nuance Your Honor points out about the perhaps different backgrounds of Ms. Nice as a witness and me, and as you said, perhaps you, I still think the suggestion that you can't be a victim unless you actually testify is so far beyond the pale that it's not a credible explanation.
Okay.
And that brings us really to the Boyette, surrounding circumstances, what Boyette calls. And I think there's a number of them here that are relevant in assessing whether the state has carried its burden of proving misconduct harmless. The first is the fact that when you look at the jury voir dire and you look at the jury questionnaire and you look at the contemporaneous financial records that Ms. Nice filed in support of her request for child support, is that this trial was going to impose a financial burden on her. We may characterize the depth of that burden differently, but the numbers speak volumes. She had $3,800 in expenses every month, $1,800 of income, $400 of child support, and I think she had $160 in the bank. So every month was going to get her deeper and deeper into a hole. We also know that the judge said 3 times when she was present, if you have a hardship, if you're not going to be paid for jury service, tell me, and you're going to get a hardship discharge. And 3 times she did not, and said she went to voir dire and became seated on the jury. So she was, for whatever reason, eager to get on the jury. We can talk about the contrasting implications. Some of those that she wanted to do her civil duty and sit on the jury. That's certainly one interpretation. Another interpretation is that she was harboring some kind of bias based on her own personal experience and wanted to get on the jury. Those are 2 legitimate explanations. During the jury trial, she gave Connor a nickname. She called him Little Man. She took the extraordinary step after conviction and after having put Mr. Peterson on death row of beginning correspondence with him, a series of letters. And the court has seen the letters. And the letters, each of them has various focus, but one of the focuses of every letter is Little Man, is Connor. And that too suggests a focus on exactly what we were concerned about with the failure to reveal that, in fact, when she was pregnant, she had been assaulted and she was in fear for her baby's life. And the final surrounding circumstance, I think, Your Honor, is that when she was seated as a juror, Your Honor will recall she was an alternate.
Yes.
When she was seated as a juror, the court has the standard admonition. Your Honor talked about standard admonitions, and here's another one the court gave. When you're seated as a juror and you begin deliberations, don't take a firm position early. Don't announce it. Discuss the case. And she ignored that admonition, as I think we all agree. Now, that isn't misconduct. It's not a mandatory admonition. But what she did say before she even sat down at the table, when she was admitted to that jury room, according to Juror Baratlas, she said, let's get Mr. Peterson for what he did to Little Man. That's not a quote, Your Honor. I may have paraphrased it, but you get the sense.
Yes.
She didn't say, let's get Mr. Peterson for what he did to Lacey. She didn't say, let's get Mr. Peterson for what he did to Lacey and Little Man. She said, let's get Mr. Peterson for what he did to Little Man. That, too, is consistent with someone who has a focus on or a history of having been in fear for her unborn baby's life. So, Your Honor, I'll just conclude on this. Your Honor made a point before to say Ms. Nice may have had a different background, and so there may be a more nuanced understanding of her statement that she wasn't the victim because she never testified. And that's true. It's also true that the state has provided explanations for almost every one of the false answers. And I'm reminded, as I have often seen, and Your Honor may have seen this experience as well, I'm reminded about the prosecutor's argument. They often make the chicken soup argument, where they're talking about what defense lawyers have tried to do, and they say, look, the defense lawyer pulls out the carrots and says, this isn't chicken soup. Defense counsel pulls out the celery and says, this isn't chicken soup. And defense counsel pulls out the chicken and says, this isn't chicken soup. And the prosecutors remind the jury, you look at it together. You put all those things together and you have chicken soup. I think there may be rational...
I've never heard that argument.
Really? Did I do it well, Your Honor?
In my many years, I have not heard that argument.
Okay. Well, I've seen it many times.
Okay.
I've seen it many times, Your Honor. And it makes sense. The point is, don't pick out things, give an explanation of this and move on. Look at things together. And I think when you look at things together here, you have the inconsistency about whether she feared for her baby's life, the inconsistency about whether she was a victim, the inconsistency about why Miss Kinsey came to the house, the non-cooperative witness. There's, again, explanations Your Honor talked about. There's explanations for every one of these things. You have the non-cooperative witness. You have the notice that she had by virtue of the publicity. You have some of the answers she gave. It was the landlord's door. It was my mother's house. I'm sorry. No, it's my apologies. You have some of the answers she gave to the questions. Why didn't you reveal the 923 incident? Well, it was the landlord's door, or it was Eddie Whiteside's tires. Any one of these explanations may be sufficient. But when you put it all together, Your Honor, I think it's chicken soup. I think we've not only carried our burden of proving misconduct, but I believe the state will be unable to carry its heavy burden of rebutting that presumption.
Okay, so let's go back to Mr. Baratlas.
I'm sorry, Mr.
Baratlas?
Baratlas, yes.
Okay. His testimony was she came in, and everyone agrees the first thing she said was something about getting him for a little man. Mr. Baratlas went on to say, we have a process. We need to sit down. We have a process. And there is no record evidence that she didn't follow that process, that they continued to deliberate, and that she engaged in the deliberations. Would you agree?
There's no evidence either way of what happened thereafter. I would agree on that.
Well, Mr. Baratlas was on the stand and could have been asked.
Indeed, he could have been asked by both parties, I suppose, within the confines of Evidence Code Section 1150.
Okay. The court's memory is, and Mr. Pat Harris is...
Sorry, Your Honor, you can't be asked about jury deliberations.
Oh,
You can't be asked about that.
No, but whether or not she engaged, continued to engage, and the court's memory is that you're correct, Mr. Pat Harris, but whether or not she engaged in the deliberations, not the deliberations, but did she engage or refuse to engage, that's not in the record, right?
My recollection of Mr. Baratlas' testimony is similar to your own, Your Honor. Neither party, and within the confines of Section 1150, which I think is what Mr. Pat Harris was referring to, beyond that, I don't think either party asked Mr. Baratlas the question you just suggested.
All right.
And so one of the important things about the burden of proof, Your Honor, is that when there's a failure of proof, that falls against the party that has the burden.
All right.
Unless the court has other questions about the existence of misconduct or the presumption of prejudice, and pending any rebuttal Your Honor is kind enough to provide, I'm happy to submit the matter.
All right, thank you. I don't have any further questions. Thank you. But I am going to ask Madam Court Reporter, do you want to, we've been going since 10, can we go until noon and then take a break, or do you need a break? All right, thank you. All right, Mr. David Harris.
Just to kind of go into this a little bit backwards, it's not where I was going to start with, but since the court had raised this particular issue, the court will find at page, reporter's transcript 352, Ms. Baratlas testified that actually Ms. Nice had come into the jury room. She was seated at the table with the other jurors when she blurted out in a forthright manner, making no gesture or gesticulation, nothing aggressive in any way, and she made that particular statement. The record further establishes between pages 364 and 367, Mr. Barattles said that after Ms. Nice had made that statement, she deliberated with the jury following the process that they had started. Further, Mr. Barattles advised that there was a second juror that was replaced, another alternate was substituted, and they in fact did exactly as instructed by the judge, where they were to start all over again. And the question was asked, did the bailiffs come in to take the stuff down on the wall? And you had to start all over again with the process, and Mr. Barattles said yes. So what we want to point out for that particular area is the People versus Bradford case, which specifically says that's not misconduct. Even if she were to come in and have said that statement, it's not misconduct because an emphatic statement by certain jurors early in their deliberations does not disclose any improper conduct on their part, and that's Bradford. There's another case, the People versus Allen and Johnson case, and what that particular case said is what we can and do require is that each juror maintain an open mind, consider all the evidence, and subject any preliminary opinion to rational and collegial scrutiny before coming to a final determination. That's what Juror Barattles testified happened in this particular case. And not only did he testify that they did that, the court will note from the record in this particular case that they reached a lesser as to Connor when it came to the second-degree murder. So that's just not only, so there is no speculation as the petitioner is pointing out here. There's actual proof that she went back there, she did what she was instructed by the judge to do, and she reached a verdict. And in fact, Allen and Johnson go so far to state the Attorney General has cited no case, and we've found none, in which a juror was discharged for prejudgment based solely on comments made during deliberations. So the law doesn't even allow for the argument that really the petitioner is making in this particular case is that she said, oh, something should happen to Little Man, or because of Little Man. That's not what the law allows. And really what's happening at that point in time is the argument that's being made by the petitioner is that they're conceding we have to prove bias. So which takes us way back to the beginning of the argument where it was originally going to start with. In this particular case, counsel, Mr. Gardner, was correct that there is the standard. We had talked about the standards in all of our briefing. Get my notes back in place here, but I just want to set the scene before we get to that particular point. As the court pointed out about Ms. Nice, we're going back to 2004. Ms. Nice is a single mom of several children who gets a jury summons in the mail. And she testified she put it up on her refrigerator. How did she know that that particular piece of paper was going to change her life, in which it has in this particular case? She'd never been on a jury before, as the court was pointing out, or counsel was pointing out, and she thought it would be part of her civic duty. Again, that's in Exhibit 5, page 4627. She showed up at court, and the process that she was originally given was she's handed this 23-page questionnaire. This 23-page questionnaire consists of over 116 questions. Almost all of those questions have multiple parts, so this is a very long questionnaire. And she testified when she filled it out, this is again her testimony here, she did the best that she could. So what we have here is a circumstance, is the testimony before this court as part of this evidentiary hearing is the person who filled out the questionnaire who made lots of mistakes. There's no doubt about that. The court's already pointed out several mistakes on there where she's inconsistent on her answers. But being wrong does not necessarily make it false or make her a liar. It just might be that she's really bad at filling out forms, and that's something we're going to talk about as we go through this. When she was brought back to court, one of the things that I really want to point out is the defense, the petitioner said all along from the beginning, Ms. Nice had this secretive motive to get on this particular case. And finances was the way that she was going to do this. She was going to, in a sense, lie to the court about her ability to sit on this jury. But the court remembers her testimony when she pointed over here to the jury box and said, I walked in, the judge asked me the question, are you going to get paid? She said, no, I get paid 2 weeks. He says, you're excused. She gets up and she starts to walk 2 to 3 steps chairs down the row, and she's stopped by Mr. Garrigus, who's trying to get the court to keep her in the mix. And the circumstances at that point in time is corroborated because it's in the transcript. The judge goes, if you're willing to be here, sit down. So she's not making this up. It's in the transcript that this is what happened. She's trying to leave. This is not, wait, I really want to be here because I'm going to secretly get this guy. You know, if that's the case, she's the world's worst spy because she's already been excused. But instead, she's brought back and she started to ask questions about being fair. So the court did point out that Mr. Garrigus and the people had the opportunity to ask questions of her, and some of those questions were asked. For example, Exhibit 5, page 4622, which was her diary transcript from the jury trial.
I'm sorry, 46 what?
4622,
Okay.
Exhibit 5, starting at line 1.
Just let me get there just a moment. I'm not sure if you have a PowerPoint presentation, but if you don't, give me a moment to get there. All right, I'm at 4622. What line?
Starting at line 1.
All right.
Towards the end of that line, she's asked, do you consider yourself to be a fair person? Making sure the court's still with me.
I'm here. I guess the question that you're talking about starts on 4621, but I'm being too particular. But you're referring to the last sentence, which is, and do you consider yourself to be fair?
Correct.
A fair person. Okay.
And so her answer is, yeah, I try to be. And again, this is Miss Nice from back in 2004 to what the court saw here during the evidentiary hearing. Can you explain to me why you believe yourself to be a fair person? Answer. Because I know what it's like to be judged, and I know what it's like to be prejudged before somebody actually, you know, how many times have you walked in a room and someone has automatically pinned you for a certain type of person, and that's completely opposite of how you are? So, question, okay, answer, I try. That's Miss Nice telling us way back then. This is the kind of person she is, and she's going to attempt to be fair in this particular case. And I go through a list of things because counsel's saying you have to look at the totality of the circumstances. Well, Miss Nice testified during her voir dire in the hearing here. She hoped she could be a fair juror for the petitioner. That's part of Exhibit 5. She had no opinion based on pretrial publicity, was open to the possibility that he was falsely accused, had no fear of finding the defendant not guilty, responded to the questionnaire candidly, truthfully, and to the best of her ability. Confirmed that at no time during the jury selection process did any court case in which she was involved cross her mind, nor did she think about them when filling out her questionnaire. She did not intentionally omit any incident with Ms. Kinsey, since they didn't come to mind. The incident with Eddie Whiteside never crossed her mind. She did not form any conclusions regarding the evidence in the case until she was called into the jury deliberation room, and she recalled discussing the evidence with the remaining jurors before a unanimous verdict was reached. She had an abiding conviction that the charges were true on the evidence that was presented at trial, and her abiding conviction was solely based on the strength of the evidence presented at trial. She had no bias against Scott Peterson. When she was selected as a juror, she listened to all the evidence and decided the case based solely on the evidence in the courtroom and not some preconceived notion. That's the facts that have been presented to the court. Those are the undisputed claims or statements of Ms. Nice about her involvement in this particular process. So what do we have from the defense? What do we have from the petitioner in this particular case? They start with their claim 1, which is that she was out to get them and she didn't indicate that she was involved in a lawsuit. So the standards, we start with Manriquez, as counsel indicated. The habeas petitioner bears the initial burden of showing that a juror did not disclose requested material information. Material being an important part. More importantly, though, an intentional concealment is strong proof of prejudice, while showing that a non-disclosure was unintentional may rebut the presumption of prejudice. Whether any disclosure was intentional or is not dispositive. And then the court goes on. The ultimate question is for whether the juror was a substantial likelihood that they were actually prejudiced or biased against the petitioner. So in this particular case, starting with that particular framework, even though counsel says if there is a false statement, the burden shifts. That's not exactly what Manriquez says. Manriquez actually is saying you may even rebut the presumption if it's unintentional. So it's a little ambiguous as to that particular point. Then there's...
Let me go back to Exhibit 1. And in the caption page, and Ms. Nice said this was her handwriting, it doesn't use petitioner and respondent. The form says plaintiff, and she filled in Rochelle Neese, and defendant, Marcella Kinsey. You'd agree that terms plaintiff and defendant can be inferred as parties to a lawsuit, yes?
There's a potential that you can infer that, but I would point the court to page 7 down at the bottom.
Okay, just a
We
moment.
start... So at the very bottom, there's something that appears to be typed in.
You know, these are not Bates numbered. Page, let's see, just a moment. There's a handwritten number. I have 9.
What I'm going to point out to the court at the bottom, I believe it's in the lower right-hand corner of that particular exhibit. It's typed in, it says civil.
Okay.
So this is a petition for an injunction, looking at the caption of the paperwork. A petition for injunction prohibiting harassment. This doesn't say lawsuit, it doesn't say crime, it doesn't say anything that might lead an ordinary person to say, I think this is a lawsuit. We pointed out in our briefing, and I'm just going to highlight this again because as the court indicated, U.S. Supreme Court has indicated, we're bringing in lay people off of the street, and all of a sudden we're asking them to understand the legal terms that we use, that we take for granted. How many times have we heard jurors sit in the box and say, my house was robbed? A house can't be robbed legally. So they're wrong. But they're telling you what they believe is the circumstances in that particular case. It was a burglary, it was not a robbery. So they're wrong about what the crime is, but that does not make them a liar. So the fact that Ms. Nice in this particular case does not think that a civil petition for an injunction prohibiting harassment is a lawsuit doesn't make her wrong. Maybe legally, if this court wants to say, I believe this is a lawsuit, then by law, by definition, she would be wrong, but is that unreasonable?
Well, how do you respond to Mr. Gardner's position that then there is, I know the people's position is there's no document in front of the court that establishes that Ms. Nice filed a second lawsuit for damages, but her testimony is that she filed something, a lawsuit, I believe, was the term that she used for, she wanted money from Ms. Kinsey. So how do you reconcile that?
So how we reconcile that is when she's asked about that, going to reporter transcript, page 42 through 43, starting at line 18. She was asked, was this about some civil suit for a loss for money? And her response was, I guess. It was with Marcella. She did say she went to court, but that's where she said she dismissed it. It was over with, and her and I came to the realization that we were both being stupid, and this was over a stupid guy, and there was no need to continue. And that's at reporter transcript 94 through 95. So what we have here is an equivocal statement on her part that there may have been a second suit. That could have been because it's the burden is on the petitioner to prove that there was a lawsuit. Because if they prove there's a lawsuit, then they prove that her answer is false. So this is the initial pleading and proof stage. They must prove that there was a lawsuit. We never heard from Ms. Kinsey. We never heard from the custodian of records for the court that shows that there was ever a case that was filed. Now they're limiting it to saying, well, you know, we didn't show any paperwork. That's true. They had on their witness list the custodian of records. The custodian of records could have come in and said we had a filing, or they could have said that there was no filing. But we know from the other exhibit, the temporary restraining order for the civil harassment, there was paperwork from that same time period that existed. There's not a transcript, not everything is there, but there's at least minute orders. So if there was something that was filed, it should be in the record. They had the witness that could have presented it on their witness list, and they never called it.
All right, but we also have a jury instruction that says that the testimony of one witness can prove a fact.
That is correct.
Okay.
But our position is, that we pointed out to the court in our briefings, Ms. Nice showed sometimes that she could be a little bit confused about things. And you saw that with some of her answers when she just started to say, sure. And when she would then be given the appropriate circumstances or shown a document, she then could explain it. And I'll talk about that a little bit later with some of the slides that were up on the screen. I also want to point something out. Counsel has indicated, and this is a subtle distinction, but the court will remember this, that exhibit number 1 was admitted, the letters were admitted, and I want to remind the court, we objected, and they actually were admitted for a limited purpose. So those particular items are not actually in for the truth of the matter. They were in for purposes of impeachment against Ms. Nice.
Well, and also, I believe, state of mind. So the letters were admitted, but not for the truth, but for state of mind of Ms. Nice, correct?
Correct. So
Okay.
then again, not for the truth of the matter. So when they're referring to the letters about what they claim to be there, it has to be directly connected to Ms. Nice's state of mind. Otherwise, there's no connection. There's no admissibility for those particular items. We suggest to the court there's been no showing of those particular items. So going back to the lawsuit, and I just want to go through these step by step.
Okay.
So the lawsuit is the first question. That's 54. If the court finds that Ms. Nice was reasonable in her interpretation that this civil restraining order was not a lawsuit, or she didn't believe it to be, that's the end of the discussion on that particular case. Now, counsel's saying the fact that she's inconsistent about dismissing a case, so therefore she should have remembered the other case. That's not how somebody's mind works. And in fact, I'll remind the court, Pat Harris attempted to try to get Ms. Nice to remember coming in on the civil harassment order and testifying. And she was asked about that even after being shown page 4 of Exhibit 1, and this is Reporter's Transcript 42, she did not remember that she came to court and testified on the restraining order. And we know that she testified because there's a minute order. So again, there's no testimony of that, but there is a minute order from that court file that shows that she was there. And that helps the court address another question that was not really answered by the petitioner about what did that judge have in front of him. That minute order also tells us that Ms. Kinsey testified. So that judge had the testimony of both the petitioner and the defendant in that particular case. And it's a total job of speculation to try and figure out what it was that was said, and that would be completely inappropriate. But they're asking you to say, we want you to think bad about Ms. Nice because, you know, that's Ms. Nice. Again, speculation doesn't work that way. And we pointed out also in our briefing, the evidence code section, that it's their burden producing the evidence, and if there's other evidence that they could produce, they could have produced Ms. Kinsey. That would have resolved this particular issue. And this is their initial burden of proving the lawsuit, so it was not our burden to produce Ms. Kinsey to say whether there was or wasn't a lawsuit. That was on them. So, evidence code section 412, as we cited, just read it real quick. If weaker and less satisfactory evidence is offered, when it is within the power of the party to produce stronger and more satisfactory evidence, the evidence offered should be viewed with distrust. The failure to call a logical witness is a failure of proof on the petitioner's part. And you'll see this repeated throughout these different things. We didn't hear from Mr. Whiteside. We didn't hear from one of the jurors that talked about money. So their burden, their responsibility to produce the evidence. So just to put this out there, the first restraining order, the people do not submit that that was a lawsuit. In fact, the people would say to a civilian that that was probably not. She didn't think that that was a lawsuit and that was entirely reasonable. As to the lawsuit for money, yes, Ms. Nice was very equivocal about that, but she didn't recall the event of coming to court and testifying, showing that she's just not clear about that time period.
But she recalled coming to court.
Well, she recalled coming to court filing the paper. She didn't recall the court coming back when she testified at the hearing as depicted in the minute order that was being shown to her. So the fact that a significant event, or what should have been a significant event of her going to court and having this hearing, she doesn't remember, when she's asked about this all these years later, just again shows the point that the people have been making. With Ms. Nice, you got what you got. She's a very straightforward, sincere witness. She's telling you, very much telling you what's on her mind and what she thinks about things. That she called it the way she saw it. We may not like that. As the court said, we may not have the same lens that she has. I think that's kind of an understatement. But that's Ms. Nice, and that's her telling it from her point of view. So the fact that she didn't remember the circumstances of even the one that she admits she was involved with, when it comes to the lawsuit for money, the people's position is that really was part of the restraining order. She was shown paperwork from the restraining order and asked about these finances. She didn't recall, said it wasn't her handwriting, but she was asked about that. It's the people's position. They were part of the same thing. And our speculation is just as good as the petitioner's speculation when it comes to there being a second lawsuit. So,
Well, but she used the term, "I dismissed it."
correct.
And it suggests, if you will, a reasonable interpretation. If you're dismissing something, that means you filed something because you're going to court and you dismiss it. But so that's another reasonable interpretation. Agree?
Yes, but if there are two reasonable interpretations, there is that instruction that would be used in a criminal case. The one that court indicates towards innocence in the criminal case would be the one the court would have to follow. Here we are in a habeas proceeding where the law says everything in favor of the conviction is the way that it should be applied. So if we were to take kind of bootstrapping those approaches here, we would find that we have to go with the one that just Ms. Nice was mistaken. But regardless, she was sincere in her testimony saying that neither, whether it was one or two, she never thought about them. They never crossed her mind when she was filling out the questionnaire because these things were behind her. She had dropped the matter or dismissed it according to her statement. As I read the statement earlier, she and Ms. Kinsey had figured out this was over a dumb guy and she had put it behind her.
Well, but not so much behind her that she said she called about Miss Kinsey holding the baby in the video. So how should the court reconcile that?
The circumstances in that particular case are, as she was describing it, she was shown a video where she saw Ms. Kinsey holding her son. And she believed that she called a family friend who just happened to be a detective, I believe is what her testimony was. We asked Ms. Bracksher about that, which is another witness we'll get to in a few minutes, but with Ms. Bracksher couldn't tell us what the entry on the screen was, that basically there was nothing that occurred, nothing, I don't recall what the specific wording was, and she said, I don't know what that means, you'd have to pretty much ask the officer. It's up to the officers to put those things in there. So once again, that's something that the defense, knowing who those officers were because they communicated with Ms. Bracksher, got the information who the officers were, could have called those particular people. They could have called Mr. Whiteside. They chose not to. And as the court indicated, he was a subpoenaed witness, and they were attempting to get in his statements through their investigator. So this was not somebody that was a surprise, somebody they didn't know about. This was just somebody, they didn't want to take the risk of putting him on the stand, as counsel indicated. That, unfortunately, pursuant to 412, that doesn't work that way. You can't then, when you have that evidence available to you, you can't then turn around and say, well, you know, it's not our problem. Well, it is their problem. The presumption is that what they offered should be viewed with distrust.
All right, so we are up at the noon hour. We're going to resume at 1:30. Thank you. I'm not putting you on a clock, but about another hour.
Hopefully. It
All
depends
right.
on the amount of questions from the court.
All right, and then, Mr. Gardner, do you want to have 20 minutes to respond? Or you don't have to.
20 minutes would be great. I think, sure I can do it in this.
All right, thank you.
Thank you, Your Honor. Have a nice lunch, guys.
Thank you. Victoria, I need you to help me find the case. Didn't find it in my notes. It's the case where we cited it in one of the last two briefs, so we just need to pull that up. It's where I'm trying to go slow.
Levi step? Oh, I'm so sorry.
So the circumstances are, the guy does not state that his wife was a drug dealer when she was a juvenile. And the defense argues that was because they asked, anybody who's a drug user or dealer, whatever. He doesn't say who. And the court specifically said the question was asked in the present tense versus the past tense. And so they found it not to be error on the part of the jury. Because that addresses one of her particular questions. Yeah, so I want to find that particular case just so I can highlight it.
Is that all?
She's gonna take.
She's gonna go move the jury help. Okay, that sounds great. Okay, that sounds good.
I just need to drink some water.
Okay, all right, okay. So Victoria, tell me what you want. And I was going to grab some snacks. So I need your key for your room so I can get all of that moved. I left my glasses on the counter. Okay. I will take those around. Yeah, everything should be in my bag. You are in room 141. 141? Yeah, can you, do you
We're almost done. We're kind of slow.
It's sitting on the counter. Okay, it's 141.
Oh, you adjusted?
Well, we'll have to adjust it. It was also verified, so it wasn't going to extend.
Oh. Okay. Yeah, she seems to be I think it was here.
Yeah, it was over on the right side.
So we're aiming here, I think.
Do you want me to sit?
Also, I'll be able to check it out from here. As good as we can get it.
Well, it is what it is. I mean, Paul, this one? Okay.
Like, who are you talking about?
Oh, very well.
Let's see. She's here-ish? Alejandra, is she about here when she's talking? Yeah. Okay. Like this, right?